Good morning, everyone, and welcome. We're pleased to have you with us today. We have 4 cases on the morning docket, and we will call them in the order in which they appear. Each side has a total of 15 minutes, and that's the fact whether there's one or multiple attorneys sharing that time. If you are sharing the time, we'll have to schedule each of you independently. The appellant has the right to reserve up to 5 of your 15 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, please let us know how much time you wish to reserve, and we will program the clock accordingly. We're honored to have our colleague, Judge Steve Stafford from Dyersburg, with us this afternoon. The Court of Appeals of Tennessee is one court. There's 12 of us, and we all sit in East, Middle, and West, and we're blessed to have Judge Stafford with us here today. We've assigned him all of the difficult cases, and so if you think you have a difficult case, argue toward him, please. So
that's why he says he's blessed.
Yes, absolutely. Of course, when I go to Jackson, Judge Stafford makes sure I'm assigned the most difficult cases, so it evens out, it works out. Are there any announcements or introductions? Hearing none, please call the first case.
Debbie Antista versus Barry Kraft et al.
Good morning.
Good morning, Your Honors. My name is Kathleen Robson-Gordon. I am the attorney for the appellants Barry Kraft and Sandra Corrine Dowd. I'd like to reserve 4 minutes for rebuttal.
4 minutes, yes.
Your Honors. Okay, we're here on a very limited issue of whether a boundary wall that was erected by my clients is a violation of the Maury County zoning regulations. As argued before the trial court and testified to by the Maury County zoning director, the boundary wall is not a violation of the Maury County zoning regulations. The county did not bring this lawsuit, rather it was brought by a neighbor. It is undisputed that the side lot of my client's property has a 20-foot side minimum building setback line. What's at issue is whether this wall is a building under the code, which it is not, and since this wall is not a building, is it a violation of the minimum building setback line? We contend it is not a violation of the code.
So all these other issues that the trial court ruled on are not appealing. Is that accurate?
Yes, Your Honor. It got limited at trial to two issues: whether the wall was in violation of the zoning ordinance, and whether the neighbor had the requisite 7 years to get color of title for the driveway and the turnaround area. We actually stipulated prior to trial that they had met the color of title for the 7 years, but we went ahead and, had the trial on that anyway. And then the only other issue out of all accounts was this one.
Okay. And is the wall still in existence at
Yes.
this time?
Yes, it is, Your Honor. Okay, so looking to the actual code, go through their definitions, right? So what's a building under the code? A building is any structure having a roof supported by columns or by walls, including tents, lunch wagons, dining cars, these types of things. So the wall is not a building. It doesn't have a roof. Next, you look to the definition.
Is there a definition of building in the code?
That is the definition of building.
That is the building.
Any structure having a roof supported by columns.
All right, thank you.
Okay, so then looking to the definition for structure, any combination of materials, including buildings, constructed or erected, the use of which required location on the ground or attachment to anything having location on the ground, including, among other things, signs, billboards, and fences. So under the code, the wall is a structure. Next, we have to look at these minimum setback lines. There is a general definition in the code for minimum building setback line, which states, a line delineating the minimal allowable distance between the property line and a building on a lot within which no building or other structure, so that would include this wall, shall be placed except as otherwise provided. The except as otherwise provided then comes into play because directly below the building setback line is the relevant setback line, the building setback line side, which is where this wall is, which is a line delineating the minimum distance between the side property line and a building on the lot. Not a structure, just a building. So the side minimum setback line of 20 feet, the definition of it does not include, you cannot put a structure in there. It only restricts buildings, not fences and structures. Per Tennessee Growers Inc. versus King, which we did cite in our brief, a statute must be construed in its entirety, and it must be assumed that the words convey the intent. So the building setback line side, which is the one that's relevant here, not including the structure, is assumed to have been explicitly excluded from that. Neither opposing counsel nor the trial court judge provided any reason as to how or why the wall is a violation of this side minimum building setback line. And I think that's because it's not a violation. Also, as cited in our brief, the trial court record shows that my clients coordinated with the zoning department before building this boundary wall. And the zoning director not only testified that the wall is not a violation at trial, he also provided an affidavit which was attached to our motion to reconsider, again stating the wall is not a building and thus is not a violation of the zoning code's minimum building setback line on the property. There is an error in my brief that I need to address. It's on page 26, and I think I know how the error happened. It's not relevant, but I say in my brief that had this border wall been on the front setback instead, it would have been a violation of the code. That is not accurate. The front building setback also only applies to buildings. You could have put this fence there, and I apologize if that particular thing caused any confusion to the court. So as cited in our brief, Calderon, who is the zoning director, stated at trial, and the trial court asked the zoning director why the wall did not violate the zoning regulations. He responded, to justify my interpretation of the requirements of the zoning setback requirements, Roman numeral II defines these. And you'll see it's notated on the survey as well, and it is, there's a minimum 20-foot side setback. In the definitions, it's defining building setback lines, the rear, the front, and the sides. Above those definitions is the definition for a building, a main or principal building. So we can extrapolate or take away completely the definition for structure. All of these building lines in Maury County are for buildings, be they the primary residence or accessory buildings, not structures, not fences.
So
these types
a building is a structure, but a structure isn't necessarily a building.
That is
under these
100% correct,
definitions.
yep. It's a little confusing. I think it's like a 700-page, it's a very long document, and I think they build on themselves, and sometimes, they can get confusing and there can be redundancies. I don't think this is one of those instances where there is one, but I think that it may have confused the trial court judge. The trial court order first held correctly in paragraph 27 that, quote, the zoning resolution of Maury County specifically defines and delineates building setback lines for the front, side, and rear of the property. However, then the order goes on to say in paragraph 29, the court further finds that the boundary wall, as erected by appellants, does fall within the minimum setback line and thus is a violation of the regulation. But it's not a violation of the side setback line. We believe the trial court misinterpreted the zoning code and just applied the wrong definition of the building minimum setback line. And, in closing, respectfully, we don't think my client's boundary wall is a violation of the clear and unambiguous wording of the zoning regulation, and we would request that the trial court order to remove the wall would be vacated.
Does the boundary wall infringe on the right to use on the property that the plaintiff required the use to right?
It does not, and that I know what you're saying. The adversely possessed driveway and turnaround. There's no testimony or holdings that the boundary wall impedes on that area. She's able to drive up. The thing is, the garage was built too close to the property line, so she can't back out of her garage to get down the driveway. So that's what the turnaround is. The neighbor needs to back out in order to get out. So then the fence and the wall encloses that turnaround area, but it doesn't impede it. And quoting from opposing counsel's stipulation at the trial court, which is trial record 3, it's the transcript, page 183, he said, "The evidence may not support everything we've asked for in the complaint, so I'm going to tell you what we would like, and then I'll try to articulate what I think what that basis would do to that. We would like the rock wall, the block wall, we would like that removed and replaced with a rail fence." Then he goes on to say something similar, so that's, we want the rock, we want the block wall removed and replaced, and we're willing to live with that. We're willing to live with this fence where it is, irrespective of who mowed what, which was like a adverse possession, evidence of that. So no, there's nothing in the record that it impedes on that.
So who owns the real estate now where the wall is located?
I'm sorry, say it again?
Who owns the real estate?
We do. So we own, I think, part of the driveway, the turnaround area, it's all on our land. But, there was, I think, a mutual mistake for a while. Nobody really knew it. It was a new development, right? But then some serious problems happened with the appellee's son was living there. There's testimony of drug use and meth and this sort of stuff. People were trespassing onto my client's property, and they were fearful. So that's how this whole thing started. And
But the property that you own, is that the same property that we're talking about as far as the adverse possession?
yeah, they adversely possess, I'm sorry, the neighbors, let's say the neighbors here, they adversely possess a little bit of our property, this turnaround area, and it was conceded and abandoned at court that everybody's fine with, leave the fence where it is, leave the boundary wall where it is, but we'd like another material for the boundary wall. They're not part of, they don't have CCRs. You can't designate material, to be used on someone's fence. They don't have a problem with the location of it, as stipulated to at trial. They just don't like it. And
Let me ask it a different way then.
Yeah.
Is the property that is adversely possessed inclusive of the wall?
no,
Okay.
So the wall in no way affects the turnaround at all. So, okay. And the trial court held, and everybody's comfortable with the plaintiff having the right of possession.
yes, we conceded
It's a
before
right
trial.
of possession, not totally
Correct.
taking the property.
It's 7 year, and I think I said a color of title didn't play in. Sorry about that. No, it's just they're allowed to use it until they sell the property, and then they didn't meet the 20 years for actually having adverse possession.
Thank you.
Okay, thank you.
We'll hear from you further on rebuttal. Good morning, sir.
Good morning, Your Honors. I'm Bruce Peden. I'm a member of the Murray County Bar. Let me start by giving a disclosure. I suffer from Meniere's disease. In the last 3 or 4 months, my hearing has degenerated. I'm hearing pretty well this morning, or at least I think so. If the court asks me a question, I may have to ask you to repeat it, or may even have to ask you to yell at me, which is.
All right. Well, we'll be glad to yell at you. I certainly respect the dilemma. I too have hearing difficulties, and we'll try to accommodate your request.
It won't be the first time I've been yelled at, Your Honor. So I'm going to just use the trial judge's words, if I can, to sort of sum up the appellee's position in this case. And the trial judge, there was a motion to alter and amend, and when the trial judge denied that in his order, he said the interpretation of the Murray County zoning resolution by the Murray County building director is not binding upon the court, nor is it binding upon the plaintiff, who by statute has standing to enforce the zoning resolution. The court finds the language of the zoning resolution specifically the definitions of building setback line and structure to be plain and unambiguous. The block wall erected by defendants is a structure as defined and was impermissibly erected within the building setback line as defined. Those definitions, I think I copied and pasted those into my brief. They're on Exhibit 4 at page Roman numeral 2-4, and the building setback line. Now that definition uses the word building. Setback line is a line delineating the minimum allowable distance between the property line and a building on a lot within which no building or other structure shall be placed except as otherwise provided. So,
Does this decision or the issue, does it hinge upon whether this wall is considered under the code a building or a structure? Is that
no, it's
dispositive?
It's a structure. No, that's not dispositive.
Okay, all right.
What's the issue, the question is whether the zoning ordinance, by its, I submit plain and clear language, the trial judge agreed with that, whether or not it prohibits structures within the building setback line.
Well, the part you quoted, and you quoted fully, ends with except as otherwise provided. And opposing counsel then pointed us to the definition of building setback line side, which says there can't be a building in that setback area, but it doesn't say there can't be a structure. Does that make a difference?
I disagree with Your Honor's reading of that provision. If you'll look at these definitions, we have a definition that a building setback line, and then it defines front, rear, and side. And those definitions, front, rear, and side, give us the locations of the front building setback, the location of the rear, and the location of the side. The first sentence essentially is the same first sentence as the first part of the first sentence of the building setback line. So I disagree that this provision says it specifically provides that you can have a building in the side setback. The definitions, the preamble to that, these definitions, the zoning ordinance at 2.020 says that the following words, terms, and phrases are hereby defined and shall be interpreted as such throughout this resolution. If we leave the definitions portion of this zoning ordinance and actually look at the dimensional regulations that pertain to the zoning classification for this property, and that's Exhibit 4 at page V-6, the dimensional regulations talks about the side yard, and it says the side yard shall be a minimum of 20 feet for a single-story structure, period. For each additional story over 2, an additional 5 feet is required. No accessory and/or detached building may be closer to the property line than the required 20-foot side setback. So the trial judge agreed with my position that it's clear and unambiguous. You cannot have structures under the Murray County zoning ordinance within the setback, and that's from that definition.
Well, are you focusing on the first line of the definition of side yard there, or dimensions of side yard. 20 feet for a single-story structure. When you're talking about stories, aren't you talking about buildings?
It says structure.
Well, a building is a structure, but a structure isn't necessarily a building. We established that earlier, I think.
Well, I don't disagree with that. I don't disagree with that, but the side yard, the restrictions are pertaining to structures and not to buildings. As the broad definition for building setback line is clear that within that minimum distance, no other structure shall be placed except as otherwise provided. And there is no express provision anywhere in the zoning ordinance that makes an exception for concrete block walls not having to meet the setback. I want to give a little bit of I'll talk about the facts, just very briefly about this. Ms. Counsel for the appellant mentioned color of title. That really color of title's got nothing to do with this case. This case, the pleadings, the complaint alleged the 7-year statute of limitations under 28-2-103 for adverse possession, which under Michael V. Jakes grants possessory rights and the right to seek injunctive relief. My client, the appellee, her property is slightly over 3 acres. The appellant's property, I think his is slightly under 3 acres. The same builder built both of the houses on these 2 lots, and for reasons that are not in the record and quite frankly unknown, when he built my client's house, he built it so close to the boundary line that you can't effectively back out of the garage without trespassing on the neighbor. My client's, one of her septic, what's called a tight line, actually it is on or was across the property line on the neighbor's property. You know, practicing law, particularly out in the country, neighbors get into disputes a lot, and sometimes they're over trivial matters. This is not a trivial matter, I respectfully submit. The way this case developed, my client, the first indication she had of a problem was she went out to the property one day and there were big rocks in her driveway. And she had to get out of her car and move the rocks to use the driveway to get up to the house. She went over to the neighbor, to Mr. Kraus' house, to inquire about that, and apparently he pulled up on the computer. It sounded like from the record, he was looking at tax maps, and he told her that your driveway is on my property. They exchanged some emails over the next few months. My client offered to buy property from Mr. Kraft. He didn't want to sell. He offered to buy her house. She did not want to sell. Eventually, he had railroad ties placed. He brought railroad ties out and placed those on the ground. There's pictures in the record of that. And those railroad ties were there for a while. He did that without any notice to Ms. Antista or without consulting with her. And then later on, he had these concrete blocks delivered and had a contractor put up a concrete block wall.
Well, I would admit this could have been handled better, couldn't it?
Yes, sir. I think so. I mean, but That's why we have courthouses, and that's why we have the Court of Appeals, is people.
Why we have jobs, isn't it?
People don't always do things the way maybe they should do things. But anyway, so this concrete block wall goes up, and this is not a fence. I mean, there's pictures in the record. This thing is, it's ugly, and I submit to you that actually what he did and the way he did it, there was a degree of vindictiveness and a degree of punishment that he was inflicting on Ms. Antista. These blocks, architectural, they got a pretty side and an ugly side. Okay, well, he put the pretty side facing his property, even though his house is hundreds of feet away from it. He put the ugly side facing Ms. Antista's property.
Is there anything in the community rules that says he can't put up a block wall? If let's assume the wall's in the right place,
No.
but yeah, so he could put up any kind of wall he wanted to, right?
He could, he can.
Okay.
He can. I researched that. Apparently there's a term, spite fence. I'd never heard of it until, and I've done some research into that, but there's no precedent in Tennessee.
I think this might be a spite wall, huh?
Well, it probably is, but anyway, so it's not a trivial matter. My client, she testified about the effect on her property, and we had a real estate expert witness that testified that this block wall seriously affects the marketability, and yes, in closing argument, I told Judge Parks what we would like. Quite frankly, I was trying to present a reasonable resolution to this problem to the court. Perhaps I should not have been posed my argument in such a reasonable fashion. But at any rate, the Judge Parks noted to me, he noted that he didn't know of any basis to order them to put up any other kind of wall or fence. And so what we've got out there, we've got a real nice, pretty split rail type fence that runs up from the road, and then we get up here and we've got this something that you would associate with East Germany right beside Ms. Antista's house. I'm just about out of time. Let me just close by I respectfully submit that I'm right about the zoning resolution. It says what it says, and the plain language, regardless of whether it's harsh or not, as I understand the law, if it's clear and unambiguous, it's enforceable, and based upon that, I'm asking the court to affirm the decision of the trial judge. Thank you, Your Honor.
Thank you, Mr. Peden.
Yes, sir.
Ms. Gordon, your rebuttal.
Morning, and just very briefly, Your Honors. I stand by the definitions section where the side yard minimum setback, it does modify the other one, but as to this page V6 of the zoning code where they say the side yard shall be a minimum of 20 feet for a single-story structure. Again, a building can be a structure. We submit that a wall is not a single-story structure. It doesn't have a story. There's also there's some overstatement as to how bad this wall is. It's a cinder block wall. There is not a substantially ugly side and pretty side, and this wasn't put up for spite. It's only on the turnaround area because of the activities that were going on by Apelli's son, which she knew about. She called the police on her own son for the drug activity before all of this. So this is not a surprise. And if he had put a rail fence there, he was worried they'd back right through it. So that's where the wall came from. And again, with no CCRs and it not being a violation of the minimum side setback line, I don't think they're allowed to dictate what material we can use for that. And the court did not rule it was within the adversely possessed area. They ruled that they thought it was a violation, or he ruled that he thought it was a violation of the minimum setback line. Any other questions?
Hearing none.
Thank you, Your Honors.
All right, thank you, Ms. Gordon and Mr. Peden, for your arguments. We'll take this case under advisement. Call the next case, please.